Now, let me share some of the messages that have come in, and then we will move on to look at Charles Antwi and why we are crying over him after his botched attempts to kill the president. This one is coming from Justice Affair Jr. in Adenta. He says, this grading, okay, sorry, you're talking about the Imani grading. We are not discussing Imani grading of the government here. Samson, I think I support the position of Atacha. The problem is not political competence, but political will. We need political will to implement this. Abbas Zalkanan, you are talking about the 40 years development program. My brother died on Thursday. Says his brother died on Thursday because Kolebu said there was no bed, and secondly, they were on strike. We were transferred to 37 military hospital, and that was where he died. Oh, sorry about that. Sorry about that. This one says, I think we allow political parties to forgo their party manifestos and strictly straight to the NDPC's programs and show the techniques of executing those policies. You say that's the way you want it. We shouldn't have any manifestos by the political parties. You didn't identify yourself. Papa Bisu in Accra sends a letter. He says, hi, seriously speaking, we will not sit down to allow any gang of group of economic saboteurs to erode the good foundation that has been laid and still ongoing by NDC government. Talk of the homegrown policies like the Atuabo Gas Kumasi Shoe Factory giving of $19 million loan to 3 pharmaceutical companies to manufacture most needed drugs in the country, and the ongoing Commander Sugar Factory project. Not forgetting our new found Sankofa huge gas deposit, which will greatly change the economy of Ghana for good via energy efficiency with the approval of $700 million from the World Bank guarantee. Ghana is on course. Papa Bisu. Well,
but doctors are on strike.
Well, he says he describes them as saboteurs who will not be allowed to.
Papa Bisu,
you know.
my friend Papa Bisu can
also,
say that.
Nene from Dansuman says we might as well give the doctors a blank check so they pay themselves whatever they want. We should turn all regional hospitals into military hospitals. I have had enough of them. Eddie in Accra says, I really love the presentation by your lady panelist. She delivers just like Madam Asla Owusu. Well, okay. These are the kind of people we need at the helm of affairs and not these family party faithful and friends. God save Ghana from the claws of this clueless, you meant to say government. Let's admit that the demands of the doctors are so high, but in the actual fact, this conditions of service is just a raw proposal by the doctors to the government. But legitimate question is, how many years does it take to become a doctor? And how many years and qualification does it take one to become a politician? And compared, okay, you're mixing up a whole sort of things. Your Concord is a bit completely absent. Adam, Abdul, Rahman, Bako in Old Kasua Barrier. You need to read your text message again before you send it. Sorry, that's what I meant to say. But you also don't forget that there are those who are arguing that the doctors get to go to school for free on the taxpayers' money. So if it takes them so many years, it is government that is paying for it. Who said doctors get to go to school for free? That's what some have sent. Plenty of that.
We all went to university. We were no medical students.
Right.
We were all subsidized.
Right.
We were all subsidized.
Yes.
Doctors are all subsidized.
In fact, the School of Medical Sciences 2015-2016 academic year fees from the University of Cape Coast that I have before me, freshmen and women are supposed to pay in excess of 10,000 Ghana cedis.
Continuing
students,
law
law places too are paying really now in 30,000s and the rest. Continuing students are paying almost 10,000. That's 9,526, and the freshmen and women are paying 10,118. Foreign students, freshmen and women, are paying US dollars, the equivalent of 19,000. And then continuing students are paying the equivalent of 18,000. So this is to also indicate to you that they are paying quite some substantial amount of money, like Egbert just said a while ago.
How many of them would have been able to afford it outside this country?
Okay, that will not take care of the
entire
another
way. If we allow them to go, none of them will be able to go.
Okay. Now, Ellie in East Legon says, much as I sympathize with the doctors, I think their demands are ridiculously outrageous. Is the leadership purposely intending to plunge the country into chaos? Question is that what their colleagues in the sub-region earn as benefits, they must be reasonable in their demand. They are simply holding us to ransom. And why are we blaming Standogbe? Sooner or later, their demands will be made public, even though I think it was unethical on his part. Okay, so if he acted wrongly, let's just say it so.
At least you check into the nearest hospital.
Okay, very interesting there. I've got lots of your messages also on my Facebook wall about the doctors' issue, but most of you are just thinking they are asking outrageously, and there are those of you who also believe that they deserve their wages and we should take care of them rather than sit there and allow people to die. Right.
But Samson, small point on the doctors, Dr. Hanson's position that the doctors are actually resigning. I have a little worry with that, because if you resign, it means that all your years of service have been extinguished.
Right.
And now that you are looking for 15 years minimum and all those things, if you are about, let's say, 50 now, and you know, after resigning, you are reinstated. I mean, you are reappointed.
Yes.
You just do 10 years and you go home, and you won't meet this.
And there's a point Rodolin wanted to make, which coincides with the proposal that Imani Ghana has been making for a very long time, that we should let the district assemblies be the ones to engage the doctors and take care of them.
That's it.
But long haul, the assemblies are also government.
Right.
Okay.
So now shall we talk about court and absolute injustice to the Mahama gunman? There is a man by name Charles Antwi, who is supposed to be 35 years or so, or is he 32 years rather, and he decided to, buy a gun, go to the church where President Mahama, he's 36 years, where President Mahama worships, where also the Chief Justice also attends church, and seek to look out for President Mahama and shoot him. His own confession is that he wanted to take that action because he believed that he had a right to the presidency. And again, the president has plunged us into doomsday, so he wanted to take his life. He was arrested, apparently with a gun. We've not seen. We don't know the details of the gun. Now, he was taken to court the next Monday, and that's the story we know. He was given 10 years jail term, and the whole nation seems to disagree with that. Why is that so? Someone who wants to kill our president, we've given him 10 years in jail, and we are crying foul. What's the problem? Let's start with Mr. Atacha.
Yeah, there is a comic dimension to this, whether doing so now is plunging people into insane delusion. So we should all be careful about this doing so business. It's getting more serious. But on a more serious note, I am of the view that there's a comic relief from the kind of economic strangulation Ghanaians find themselves, under the mismanagement of the NDC regime. So when we are looking at doomsday and some of the serious problems, here is a gentleman who in his own world is trying to do something mischievous. Well, in the first instance, we should bear in mind that the law is a serious forum. I hold the view. And I always say, without trying to be insulting, that those who are in charge of the court system should take matters seriously. I'm very saddened for one reason, that the prosecutor gives a narration which is indicative of the fact that the case was not concluded.
Right.
I don't know what here is anything to go by, but what he said here is very funny. I don't know whether it's Burkina Faso in Nkranza. You see, if I should quote some of the facts here. In the course of investigation, accused admitted ownership of the gun and said that he bought it from a national of Burkina Faso in Nkranza. You see, in the Broadhalf region.
So the Burkinabe was in Nkranza.
It was in Nkranza. That's what we're trying to talk about. Okay. So these are, with all respect, leads that the police will have to investigate. And then also, further investigation is being conducted to find the source of the gun and the intentions of the accused person. It is therefore a prayer that the accused be remanded into BNI custody to assist further investigation. For me, that gave the judge, the opportunity to remand the accused person, no matter what the accused person said. And I've also, looked at what he said. You could see that you don't need an expert to tell you that he was mentally challenged. He was in the realm of insane delusion, because I am of the view that if you dislike the president, the way to get him out is via the ballot box and not through assassination. So when you put all these issues together, we come back to what the law says. It should have ministered to the judge, with all respect, that this man needed medical investigation and audit, if you like. Because if you pay regard to Section 133 of Act 30, it is so clear
the
that
Criminal and Other Offences Act.
The Criminal and Other Offences Act, Procedure Act of Ghana. It provides that where in the course of a trial or preliminary proceedings like this one, the court has reason to believe that the accused is of unsound mind and consequently incapable of making a defense, it shall require into the fact of such unsoundness by causing the accused to be medically examined, and shall, after examination, take medical and other available evidence regarding the state of the accused's mind. So I'm of the humble view that at the threshold, a man who has a problem with the president, who believes that he doesn't like the do-so situation, and I'm telling you that he's having a mental delusion after Professor Mills, he should be the one in charge and the rest of them. At the threshold, this judge that make a reference that, look, remand this man, but make sure that he goes for psychiatric.
Does it not matter that we are told that the judge asked the prosecution whether the gentleman had a problem, mentally, and they said no because they had, checked him out, and he wasn't.
Well, it was not for the prosecution to now assume expertise in psychiatry and the rest of it. The judge should be, excuse me to say, I would want to use some funny word, but the judge should see through all these things. The prosecution, if they didn't believe his storyline in the first instance, should have first made let them go and confront a psychiatrist. And that could also be part of their facts. But what was narrated in the court, I am of the humble view, was a clear-cut case that it should go for psychiatric examination.
Okay.
And then I am also of the view that when the judge said the man has said something which was indicative of a confession, against the backdrop that the prosecution itself wanted some time allowance to investigate this matter, should have, said, well, from the way it's going, I won't take your confession seriously, because if the matter is not concluded, and therefore I'll enter a not guilty plea for you until investigations are concluded. But what was outrageous was the fact that the man has been charged with the offense of possession of firearms without lawful excuse under Section 11 of NRCD 9 of 1972, which gave a maximum sentence of 5 years. So I don't know what had arrested the judge's feelings, maybe over sympathy for the establishment. He gave him, 10 years. I think he's acted outside his jurisdiction, and
Abraham,
these are matters.
Abraham, I don't know. Do you subscribe to the remarks that have been made by Mr. Atachian. And to begin with, when you look at the charge sheet, it says that statement of offense, possession of firearms without lawful excuse, contrary to. Then you see that it's written, typed, section 1921 of the Criminal and Other Offences Act, 1960, Act 29. Then you see that that part has been cancelled with red pen. And then the red pen has been used to now amend by inserting a new law, section 11 of the Arms and Ammunition Act, 1972.
There's nothing wrong with this, except that I thought that he should have signed across.
Initial
to show that
okay.
he's changed the charge.
But
this is done every day.
But Samson, the fact of the matter is that when he's presenting the case, he will state it to the hearing of the judge.
Right.
You understand? Yeah. So this is the paper he has with him, and he will state it to the hearing of the judge that under section 11 of the
NRCD.
Yes.
So what do you have to say about this process?
Is it process? But you see, the president, it was a close shave for not only the president, but also the Chief Justice. Indeed, I'm not sure if the convict has succeeded, who would have been sitting here today. I am sure that this country would have been plunged into civil war. When you hear the narratives...
Or would have been plunged into mourning or civil war?
Oh, civil war.
Why?
See, the death of
the president.
A president in Burundi caused 12 years of civil war. In Rwanda, it was a genocide.
Professor Mills died, there was no civil war.
They didn't kill him. Now, the point is that the issues as people are talking about, the narrative, seems to be tilting towards the defense of the accused person. Lawyers espousing the law and pointing out some loopholes. I agree. But I thought that in the same vein, those people should have also been talking about the security, showing concern for the security of our president.
I think they have done.
No. I have heard people who were interviewed. They were only based, and even the Ghana Bar Association has offered to assist.
That's so.
And in their statement, they didn't say anything about the gun regulations, about this country, how we can tighten our security, and particularly for the first gentleman.
Oh, in their statement, I thought they took a serious view of that attempt.
Yeah. Precisely.
Attempt at killing the president. They took a serious view and then just said to set the law right, the record straight, they are offering support, or they are going to take steps or offer support to anyone, any lawyer who was willing to go and correct the procedure.
I have no problem with providing legal aid to the accused
convict,
person, the convict. But I think that the narrative for me should have been weighed towards how do we provide security for our president.
But that will not be an issue for miscarriage of justice. That's a security matter. Now, what we are addressing is miscarriage of justice.
Now, when you look at it, exactly they are not the same. Exactly they are not the same. If this man has succeeded, I'm not sure, as we are sitting here, we will be able to even talk about the injustice which will be meted out to the accused person.
With
the accused person, an appeal can reverse everything. Just single appeal can reverse all the things that they are talking about.
An appeal is even a long way to go. Just go quash it via Secretariat.
Yes, just an appeal can reverse all these that we have pointed out in the trial. But if the president had been shot dead in this country, I'm not sure if we had recalled all the doctors on strike, they would have been able to revive him.
But that will not compensate for miscarriage of justice.
No, you don't understand me. If you don't do my submission for me, that's not where my interest is. Your interest is with the accused person. My interest is to protect my president. So I am of the view that in doing the narrative, we should balance the equation and also look at how do we ensure that our president, even including you members of parliament, are protected. Now, when you look at this particular case, I am of the view that the judge could have done one thing. That is to adjourn and ask the accused person to look for a lawyer. Because under the Constitution, you may defend yourself or you may ask a lawyer to defend you. When he asked the accused person, now a convict, whether he has a lawyer or not, and he said he didn't have a lawyer, he shouldn't have continued. He should have adjourned, given me the opportunity to look for a lawyer. If he fails to get a lawyer, at the next agenda, he could have continued. That, for me, was the issue that...
Or more appropriately, he could have referred to legal aid for a lawyer. Or the judge himself could have appointed a lawyer.
With the law that my senior has read, this law provides that where the judge or the court has reason to believe, it is discretionary. So this judge can say that, looking at him, having interactions with him, engaging him, I didn't have any reason to believe that he could not comprehend and understand what was going in court. So the judge will have a defense here in respect of that. But it would have been good if he had referred him to the psychiatric hospital. Okay. But the judge has a defense here.
Right, let's hear another lawyer. Egbert, again, as we know, and you have engaged on this matter quite a bit, if it is the case that he was being tried under the Criminal Offences Act, that is a felony. Yeah. And that's an indictable offense. Yeah, so he ought to have gone through a trial, not a summary process. Yeah. So that is also a difficult thing to understand, isn't it?
Yeah, I think that what happened in the court on that fateful day procedurally was wrong. Wrong because the gentleman apparently pleaded not guilty.
Right.
So when a man has pleaded not guilty, all that the court does is to make an entry of his plea, it is mandatory, and remand him if it so wishes, or if he wishes, grant him bail.
But the law also requires the judge to enter a plea of not guilty for a person when they have pleaded guilty and yet their explanations suggest
guilty with explanation
that they have some explanation.
Yeah, straight away, it is there. I mean, it is more...
No, I'm asking that if the judge can put a plea of not guilty in your favor when you have actually pleaded guilty, why can the judge not do the other way around?
Because that is in this same principle of erring on the side of caution. You understand? I mean, Blackstone says that it is better that 10 guilty persons escape than that one innocent suffer. And I use innocent here in quotes. This is a case where prima facie, the gentleman had a weapon on him. But in this country, to take ourselves serious, we don't try, excuse me, mentally unstable people.
It's true.
Otherwise,
mentally unstable.
No. Abraham, please, let me. I know this is a matter that is dear to your heart.
It's not only in this country, but
but it is a standard.
That's
you must be fit
law.
No, you don't be able to stand trial.
Who are not compos mentis, so to speak.
Yes. But who determined that the man was mentally unsound?
Okay, now he proceeds there.
Honorable Atachian has read to you the provision of the law. You say, according to your interpretation, that provision, the section 133 of Act 30, gives the judge a discretion.
Right.
Good. So the judge has exercised his discretion. Good. Period. But Article 296 also, gives the conditions for exercising discretion.
Right.
In this country, it must be fair and all those things.
It must be candid.
It must be candid. Do you think what happened was fair? I don't think it was fair.
You appeal against
I don't think it was fair. Now, the other issue is this. Even constitutionally, you look at Article 19. Article 19(2)(e) provides that a person charged with a criminal offense shall be given adequate time and facilities for the preparation of his defense. This was not a lawyer. The interpretation of adequate time for preparation of his defense. If he had pleaded not guilty, let's say he had even testified, was he not going to call a witness? So that time and facilities, adequate time and facilities, if it includes, and I submit so, that it means that you can call a witness, was he given the opportunity to call a witness? No. It is a travesty of justice. Indeed. Look, the world is watching us, you understand? And I think that eminent jurists have acquitted themselves so well in this country that our judicial system is, at least in the Commonwealth realm, it is respected and accepted. Right. And some of us are worried, about the way this matter went. I want to genuinely believe that the learned trial judge, possibly did not advert his mind to a whole lot of things, especially against the backdrop of the personalities involved. You understand? But all said and done, Honorable Atachi also raised a point. Till date, we do not know the truth behind the murder of John F. Kennedy. You know why? Because on the day that Lee Harvey Oswald was being taken to a courthouse, up turns a man called Lee Harvey Oswald is the one who did the assassination. Up turns a man called Jack Ruby, follows up to the FBI agents and pulls a gun and shoots Lee Harvey Oswald. Next thing is that the FBI agents also quickly shoot Jack Ruby. And so Lee Harvey Oswald dies, Jack Ruby dies, and to date, whatever went into the assassination of Kennedy, America has not been able to establish it. So let's say this was a grand scheme, you understand? This was a grand scheme, and so there are 3, 4, 5, 6, 7 people involved. Now that you jail the man, are you able to go and ask him questions about it? You cannot, you understand? So, I mean, the family knows what to do. I'm sure that they will go on appeal.
Even after his conviction and sentence, he was in the police van.
Saying all kinds of things. It's on Joy TV. You understand? I mean, yes. I don't feel confident and good as a Ghanaian knowing that prima facie somebody who appears not to be compos mentis is, as we speak, languishing in jail after a purported trial. I think it is wrong.
Just hold your peace. Just hold your peace. We'll take a quick break. We'll be right back. Okay, a quick straight answer from Egbert to this questioning, and then we'll hear from Rodalyn and do wrap up. Professor Kwekwasare says, under Article 151, a judge may be removed by the Chief Justice on the advice of the Judicial Council on grounds of stated incompetence. In my opinion, the mistakes committed by Judge Obiri amounted to gross incompetence of the type envisaged by Article 151. It is not that the outcome was wrong. It is that the process was so fundamentally flawed that all defendants should have concerns about appearing before Judge Obiri. I hope the Judicial Council has taken notice of the gross incompetence and is taking steps to investigate and advise the Chief Justice. Should there be any investigations at all about this?
I don't think so. It is an act of omission, but I don't think that it warrants the kind of strike that the said article. You see, let me also quickly chip in this before she comes in. The judge should have adverted his mind to the fact that the state attorneys are on strike. For a case of this nature, I don't think that the police are the ones who are going to prosecute it. The person was just brought to the circuit court for a remand, and possibly it will be taken to the High Court, where a state attorney, whether the principal state attorney or even the director of state prosecution, will come and take over. So it was just to satisfy the constitutional requirement of 48 hours, and then you grant the person bill that the case was sent there. So I think that, you know, the judge was, with due respect.
And in fact, if you are doing it on the law on which he was convicted for more than 5 years, you need the written permission of the Attorney General to be able to commence a trial in that case. But I want you quickly to speak to this. Professor Kwekwasare is saying this is a classical case for this judge to be investigated and removed.
With all respect to Professor, one instant cannot be a measure of incompetence. And there have been very serious cases in the Supreme Court.
Judges don't swear an oath not to make a mistake. That is why the appellate process is
precisely
there. But he says this one is such fundamental.
I do not think so. I do not think so. I think that some kind of euphoria might have arrested him. But if you look at his record, and you compare his record, and then the end result is that, oh, this judge is just, they call him Mr. Blunderful.
Right.
Have you heard that expression?
Yes.
This judge is Mr. Blunderful.
And that's what surprises a lot of the lawyers. What do you say?
So I know Justice Obiri well.
Yes.
His criminal law is good.
Very
this
good.
could just be one of the omissions. You have bad days.
But an omission that goes so much to the core.
We all have bad days.
An omission that goes so much to the core, that has the potential of eroding all the good things he's done.
But that is why it is good that we have this appeal process that can undo some of these things. You don't need to investigate him for what.
And then who compensates him for the
period? Prof suggests that elsewhere, where he is in the US, he would have been a candidate for removal by now.
One error.
Yes.
I'm afraid that would be too much.
Okay, right. Now, Rodley, what do you look at? People are saying, why? This is a man who confesses to wanting to kill the president. Why should we be bothered that he's giving just 10 years in jail? He's sick, so what?
He's sick, which means that he's not of the right, sane mind to actually understand what he's saying. Because if I know that by saying...
He understood what it takes to prepare to go buy a gun and come look for the president's church and go sit just next to where you could get him.
Look, we all have a bit of insanity in us. Sometimes we do things that we don't understand, but people don't call us mad. Okay? But at the same time, this is somebody that even listening to the mother, when she was making her submissions, I got the feeling that he's sick in the head, and maybe the judge should have just exercised a bit of restraint.
She's been taken for treatments a number of times.
Yeah,
and she's
the
been
prayer sessions,
camps,
and he's run away and all that. So the judge should have at least allowed him to go for a psychiatric assessment, and then that would have at least informed him as to whether he was of sane mind or not. And then I just looked at it and I said, wow, this is one of the fastest cases that I've ever had. Arrested Sunday, jailed on Tuesday. If we had that kind of justice, that kind of thing going for every other case, not the 5-year, 3-year cases that we're having, would have been maybe a better country. But for me as a layperson, I felt that we actually lost the opportunity to know exactly what was in his head and if there were other things. We don't know if there were other people involved. Maybe he could have been with other people. We don't know because we've sentenced him to jail. But we could have at least taken time to investigate further on, to know exactly what was happening. I think that we didn't do a good job. And
I was just telling my senior attached here that there's a need at least to have a chapel in the presidency and then even a mosque, so that you don't have the president going out to be doing these things outside.
No, but
what about a shrine? What about a shrine?
They need to mix.
What about a shrine?
They need to mix, but you cannot give the president that kind of security as if it's a safe match.
What is this?
No, but this is Ghana.
Okay.
This is Ghana. No. I don't think the president is at risk in this country.
Here is Abdul Malik contributing from afar. He says, civil war between which ethnic groups or communities? A potential for political instability and a serious threat to national security, law and order. Yes, but a civil war is hard for me to contemplate, unless, of course, Amaliba could provide us with further and better particulars which would indicate the clear lines of conflict. In this case, civil war between which groups or communities or tribes. If indeed the guy was jailed for possessing a gun without lawful excuse, and if an intention to assassinate a president is deemed a criminal offense, then of course the option of continuing investigation into the latter is still on the table, or admittedly the handling of the case so far has undermined the integrity of the judicial process. It isn't a fatal injury, though that's what Kweku thinks. It isn't a fatal injury. Justice delayed, they say, is justice denied. Is justice denied. However, it is also said that justice hurried or rushed is justice buried. Thank you, Abdul Malik, for your views from afar.
Now, the cases in Rwanda and Burundi were totally different
That's
on
correct.
this situation.
That's correct. Now.